Welcome back to Uncivil Law. Ever wonder what happens when cutting-edge technology meets deep-sea exploration and disaster strikes? Welcome to today's episode where we're diving, pun fully intended, into one of the most harrowing maritime tragedies of recent times, the Titan submersible explosion. But folks, we're not just here to recount the tragic events. We're here to explore the complex legal maze that has emerged in the aftermath. Grab your scuba gear. This is going to be one deep dive. All right, let's set the stage. Picture this. It's June 2023, and the OceanGate Titan submersible is gearing up for what's supposed to be an epic adventure down to the wreckage of the Titanic, a journey to witness history, buried 12,500 feet beneath the North Atlantic. But instead of a treasure trove of maritime history, what we get is a front row seat to a modern day tragedy. When the Titan lost contact with its support vessel, the Polar Prince, 90 minutes into the dive, alarms went off and a frantic search began. Days passed, and the world held its breath, hoping for a miracle. But instead, we got devastating news. The sub had suffered a catastrophic implosion, taking all 5 passengers with it. Some might think that this is a tragic accident and nothing more. But not us, my friends, because this is where the legal case kicks into high gear. Welcome to the wrongful death lawsuit filed by the family of Paul Henry Nargeolet, one of the ill-fated crew members. They're not just seeking justice, they're looking to peel back the layers of the negligence that they believe led to this catastrophe. So what's the legal scoop? The lawsuit accuses OceanGate and its CEO, Stockton Rush, of what's called gross negligence, otherwise known as recklessness. Imagine driving a car with faulty brakes on a winding mountain road, but knowing full well that those brakes might fail at any moment. That knowledge is what produces recklessness. Now substitute the car for the submersible and the winding road for the pitch black, pressure-crushing depths of the ocean. You get the picture. The lawsuit highlights several key points of this recklessness: Titan's unconventional design, its lack of any certification, and get this, OceanGate's refusal to submit to industry standard safety checks. It'd be a little bit like going to a gourmet restaurant, but being told, sure, our chef doesn't believe in food safety inspections, but trust us, the food is fine. As for me, this kind of statement doesn't exactly instill me with confidence. Now, let's talk about the legal meat and potatoes behind this lawsuit, a wrongful death claim. In the simplest terms, a wrongful death lawsuit is filed when someone dies due to negligence or misconduct of another party. In this case, Nargeolet's family alleges that OceanGate's recklessness and carelessness directly caused the death of everyone on board the Titan. But wait, this lawsuit gets juicier. The lawsuit claims that the crew likely knew they were doomed long before the actual implosion, but carried on anyway. Imagine being trapped in a steel coffin deep under the water, hearing the crackle against the hull as the pressure mounts, knowing that your fate is sealed. It's the stuff of nightmares. And what the lawsuit alleges is this is what the crew experienced in their final moments. So what does this mean legally? Well, if the court finds out that OceanGate was indeed reckless, it could mean a hefty payout for the plaintiffs. But beyond the money, this case could set a precedent for how deep sea exploration and other high-profile tourist experiences might be regulated in the future. We're talking about new laws, stricter safety standards, and possibly even halting similar expeditions until we can be assured of their safety. Hopefully, this lawsuit won't just be about getting justice for these victims, but also about preventing future tragedies. Because, let's be honest, no one wants to see a sequel to this particular disaster. Let's talk a little bit more about one of the defendants in this case for a second. Stockton Rush, the CEO of OceanGate, is described in this lawsuit as an eccentric and self-styled innovator. Now, I don't know about you, but when someone describes themselves as an innovator while cutting corners in safety, I start to hear alarm bells. And these alarm bells, at least to me, are the kind that tell you that you should run for the hills. The lawsuit paints Rush as a reckless leader who pushed the boundaries of what was safe, all in the name of innovation. And while innovation is great, hey, we all love our smartphones, there's a time and a place for pushing the limits. The bottom of the ocean, with human lives at stake, probably isn't it. As for likely defenses, one of the key defenses is likely going to be the legal concept of assumption of risk. Assumption of risks means that you willingly participate in a known dangerous activity. You're essentially acknowledging all the risks that come along with the inherent nature of the dangerous activity. It'd be a little bit like going drag racing. If you, through your own conduct, cause your car to wreck, you can't exactly sue the track because you were an idiot. OceanGate could argue that the crew knew what they were signing up for, a perilous dive to the Titanic. After all, deep sea exploration isn't exactly a walk in the park, and the dangers are inherently obvious. But the plaintiffs are likely to counter that argument by saying, sure, they assumed some risk, but they didn't sign up for something known by the owners of OceanGate to be a death trap. The idea of exploring the deep ocean is as old as humanity's fascination with the unknown. From ancient divers using hollow reeds to breathe underwater, to modern submersibles capable of reaching the ocean's most remote depths, we've come a long way. But with that progress comes responsibility. A responsibility to ensure that those explorations are as safe as possible. The Titan disaster is a grim reminder that innovation without safety can lead to catastrophe. And this lawsuit is likely to explore that very idea, whether the push to be the first, the fastest, or the deepest justified the risks that were taken. So where do we go from here? The wrongful death lawsuit is still in its very early stages, and court decisions could take multiple months, if not multiple years. But the implications behind this are already being felt. OceanGate has suspended its operations, and the deep sea exploration community, as well as other high-profile tourist communities, are taking a hard look at their practices. This case could be a turning point in the approach to the unknown when it relates to commercial exploration involving tourism, whether it's the depths of the ocean, the far reaches of space, or any other dangerous frontier. The question isn't just, can we explore these spaces, but how should we do so, and under what safety circumstances and regulation? As we return to the surface from the depths of this case once again, let me leave you with some food of thought. What responsibilities do you think companies like OceanGate should have when pushing the boundaries of exploration? Should adventurers assume all risks, or should there be stricter regulations to protect them? And most importantly, what lessons can we take from the Titan disaster to prevent future tragedies? Drop your thoughts in the comment section below, because in this courtroom, everyone's opinion matters. Until next time, I've been Uncivil Law, and remember to keep it uncivil out there.